to demoralize the judicial officers and obstruct the ongoing process of adjudication of objections in the laptop cases. As per that, we will not allow anyone to interpret and cause any and take law in their hands in order to create psychological fear in the mind of the judicial officers who are performing their solemn duty. Yet, undoubtedly amounts to criminal contempt within the meaning of section so and so of the Contempt of Courts Act. Besides, it also exposes the complete failure of the civil and police administration in the state of West Bengal. The manner in which the Chief Secretary, Home Secretary, Director General of Police, the Collector, and the Superintendent of Police have acted, is highly deplorable. They owe an explanation to this court as to why, upon being informed that the judicial officers have been captivated at around 3:30 p.m., failed to take any effective measure for their safe evacuation. First, it was imperative upon the state administration to immediately inform the Election Commission of India and seek assistance and seek the central forces and seek deployment of the central forces to ensure safety of the judicial officers
and the family members.
whenever necessary.
And the family members. We had one bad experience. Joint Director CBI's house was garrowed and he was under a siege till the Home Secretary of Union sent central forces to bring the family out. It's an affidavit before your lordships.
No, but that's
Some
another
other
matter. No, nothing happened.
So
to them.
family also, my lord.
That's in a different matter. Nobody.
Secretaries who my lord the Chief Justice mentioned, these are transferred officials put in there by the ECL.
They are worthless.
You're absolutely right, my lord. They should have answered the phone.
They have not been imported from the other country.
Yes,
indeed, my lords.
Yes,
It's
yes.
only to drive fear into the hearts of
Some have been got from
Five
the
officials,
streets, my lord.
others
Only to
are
drive fear.
relevant or
These, my lords, these three individuals were appointed on 15th and 16th of March. My only suggestion is let it be personal affidavits of these three.
Yes.
Let's,
As well
It
as the SSP, the collector, all were the state of.
Correct. So these three should file personal. Let it be personal
Let's-
affidavits. my lords,
That's
because they
only
have
to
to give an
derail
explanation.
the process
It's very
and to
it's
Why
a
did
very
they not
sorry
to their
situation.
hearts.
If the Chief Justice says that I am not able to get the mobile number of the
Let-
Chief Secretary, it's shocking.
Yes.
And it should not have happened. There's
You
no
need
question
Let the
about
government
it.
have no
Let
say in
personal
this
affidavits
matter.
come.
Why is he not taking the Chief Justice's call?
Let the government have no say. The Honorable Chief Justice of
We are not
Calcutta
having
has
a
been
say.
aware.
That's why we are saying
And
personal
the Commission
affidavit.
will take all remedial
They
steps.
are answerable, my lords, to the people, to the election
Unless they
commission.
wanted to
Why have they
derail the
not taken-
process and they want to terrorize the judicial officers who are impartial.
These are your officials not taking the Chief Justice's calls, Mr. Naidu. I hope the conference is going well.
Nobody would expect that people would be, judicial officers would be taken for ransom, held hostage. And such is this Jungle Raj.
In cognizance of the yesterday's incident and with a view to ensure that no obstruction or impediment is caused in the ongoing SIR process and trusted to the judicial officers, and with a view to assure all the judicial officers that their life, liberty, property, and family members will be duly protected under the orders and directions of this court, we deem it appropriate to issue the following interim measures for immediate compliance. One, the Election Commission of India is directed to requisition a directive for acquisition of the central forces, adequate central forces, and deploy them at all places where the judicial officers are adjudicating the objections in the under the SIR process. Right?
Also, the hotel.
Why? Similarly, adequate security shall be deployed at the places, including hotel or government guest houses, etc.,
Where they are presently.
where these officers are presently staying. Three,
Let a crime be registered against these miscreants, my lord, so that it will serve as a
My lord,
lesson.
family members
They cannot
also,
go
because the next
scot-free.
target would be the
Must
family.
be done.
They should
Must
be
be
brought
done.
to book.
Similarly, the family members.
Boarding schools on that.
Well,
Perception
a
can be
judicial officer on
assessed
duty
by this.
has any apprehension, any security of his family, his or her family members, such threat perception shall also be immediately assessed and adequate measures will be taken. Police appreciation and adequate measures as may be required shall be immediately taken.
My lords may say this for the appellate tribunals also, because I don't know what could happen on the streets.
So now let us not expand it to that.
No, no,
Yeah,
I'm
that's
just
my
saying,
point,
if
right.
they want,
Because
No, no,
it has
that's not
addressed
the
the
point,
core
right.
issue now.
it's not our responsibility.
It's not the
Next
point right now.
Kindly observe, my lords, is Election Commission is entitled to take all remedial steps necessary.
Yes, we have indicated, Mr. Naidu, we have indicated.
What is the
All remedial steps by the election.
That's the job.
Election Commission of India and the state government are directed to take all remedial measures that
Grateful.
to ensure the safety and smooth functioning of the responsibility entrusted to the judicial officers.
From
So,
your
Your
lordship's,
consider
Grateful.
saying
from your
the state
lordship's word
government
of
as
assurance.
directed by ECI. Please do not leave it to them,
The state government as may be directed
by the ECI.
Yes.
Millards.
My lords, I think it's the state
Kindly-
government and the
kindly
election
give a
commission.
word of
My lord, if I may,
Is tasked
From your
if your
to-
lordships may kindly permit me
Kindly
to
have a word of
say a few
assurance to the
words.
judicial officers, my lords.
Right.
Kindly have a word of assurance to the judicial officer.
All
My lord,
the
may I say a few words?
Secretary, Home Secretary, Director General of Police, District Magistrates, Senior Superintendent of Police, and all other police officers
Yes,
are jointly and solely directed to ensure that not more than 3 to 5 persons will enter the premises at one point of time
yes,
for the purpose of filing the objections and or at the time of hearing of such objections.
yes.
In none of the premises where the adjudication work is going on, more than 5 persons shall be allowed to assemble, for which adequate measures shall be taken during the course of day itself. Also, the next program, the Chief Secretary, the Director General of Police, and the state Mr. Naidu, your representative will be state electoral officer
I think so.
and the state
Yes,
electoral officer
Chief Electoral.
Chief Electoral Office.
If I'll have to.
are directed to send to submit a compliance report.
Yes,
Next program. The collector, the superintendent of police, or you start from the top one, the chief secretary, the Director General of Police, the District Magistrate, and SSP are also directed to show cause
Yes, sir.
as to why
Yes,
suitable action be not taken against them
yes.
in light of the contents of the DO letter received from Honorable Chief Justice of the High Court. High Court of the state. The registry is directed to forward copy of the DO letter received from the Chief Justice to all of them. They are directed to remain present online on 6th April.
4 p.m. my lord.
May I pray for a word of assurance and encouragement to the judicial officers, millets, from your lordships? They're in a state of fear, obviously.
Yes, Mr. Naidu?
Millets, my lords may observe a word of assurance and encouragement to the judicial officers who are in a state of fear now. Some reassurance from your lordships that your lordships have been watching and then they are protected.
It's already reflected in your lordship's order, my lord.
It needs to be, millets, given the scary situation there.
Who will investigate the yesterday's
Sure.
picture?
ECI should have appointed more
Yes.
responsible officers.
Officers, ECI has ensured these transfers. You should
ECI
Yes.
takes the person in who doesn't give us
Yes.
mobile number to the Chief
Then
Justice.
let's set the better how with
The
a straight
secretary
face
the
is
better
and
appointed,
lines.
the chief secretary is
They-
appointed by
they
the
file a
ECI. He
bill.
doesn't take the chief
They
justice's
file a
phone
bill
calls.
with all
The
three.
case is more
And I-
concerned about the
dismissed.
transfers than the
And
incident.
then
These
just
This
to
is what-
personal affidavits.
challenge
May I
the
be-
court,
may I
they
be-
have done this one.
May I be permitted to tell something, Milord?
Millets, they have filed a bill.
May I
putting
be
all the
permitted to
fees
say
for the
something, Milord?
transfers. They lost it.
Just a minute, we also direct the Election Commission of India to entrust the inquiry stroke investigation in yesterday's incident to an independent agency, that is either Central Bureau of Investigation or National Investigating Agency.
Yes.
That investigating agency.
Grateful.
To create orders to this effect shall be passed
Can't be with that.
during the course of day.
Under your lordship's monitoring.
A compliance report to this effect shall also be submitted to this court. The agency to whom investigation shall be entrusted, shall be obligated to submit a report directly to this court. To submit a preliminary inquiry report directly to this court.
Grateful. We will do.
Wants to say something. Yes.
I think the Advocate General, he needs to be unmuted.
Yes, Mr. Doctor.
And I
Yes,
be
we are-
permitted to say,
My lord, if your lordship may kindly permit me to say a few words. Now that the matter is over, my lord, your lordship has the entire facts before your lordship as to what has happened yesterday. Number one thing which I wish to highlight is that, my lord, the ECI should not be acting as an adversary in this matter, because we all are aware that, my lord, the judicial officers are to be protected. My lord, your lordship's orders.
Mr. Advocate General, unfortunately in your state, now you are compelling us, each one of you speak political language. That is the most unfortunate thing. We have never seen such a polarized state. That we are even in compliance of court orders, the politics is reflected. You want us to...
My lord, may I say this, my lord? My lord,
That is
may
what
I say this, my lord?
we thought
But
that-
so far as, my lord, the safety and security of the judicial officers are concerned,
Judicial officers. It's only because
You see.
both parties were happy. We thought that we are creating a neutral, a kind of a structure for the purpose of, so that none of you have any grievances. And this is how
Yes.
people are behaving. Do you think we are not aware of that? Who are the miscreants? At least I have been there till 2 a.m. in the night. I have been monitoring everything.
yes, my lord, I am quite aware, my lord, that, my lord, your lordships, my lord, have taken the trouble of, my lord, hearing this matter.
Very unfortunate.
Malas, may I make a small request, Malas, if you obviously don't mind, Malas.
May I
Your
make
Lordship,
one
sir, in the
request to
course
your
of the
lordship?
order
Can I
mentioned
make?
that a complete breakdown on law and order, Malas. I request you to modify that. That's my request, Malas.
My lords,
Because if we have
that's
other
a naked
repercussions.
truth.
Other
May-
That's a
commenting.
naked truth.
May I make
Anybody
one
who is
request to your lordship?
specific
My lord?
only there.
One, leave it now. I'm making a request. Why do you?
They are
It's my
throwing a
request.
challenge to the authority of this
second.
honorable court.
It's a request I'm making, Malas, Your Lordship.
Either
But
may,
if
my
this
way
is
or
not
no
why
way.
I'm posing a question to myself,
Vipul,
what there can be.
Yesterday, what has happened? At least at that place, do you think that there was?
At that place, I can understand, Malas, but when Your Lordship, Malas, with respect, Malas,
Without observation, they are bound to have.
please
My
do
lord,
that,
may
Malas.
I
Otherwise,
make one request?
it has repercussions, Malas.
No, we are not using word in this state. We have used.
No, there cannot be any
Your
Malas,
Lordship
may I
has said
make
it
one?
can be misinterpreted.
My lord,
It
My
can
lord,
be
may I make one
misinterpreted. It's my
submission?
only request, Malas, that Your Lordship may just
We understand your submission, we will take care.
deeply obliged.
We are requesting,
May I
please,
make one submission to your lordship?
that people should.
May I make one submission to your lordship, my lord? May I make one submission to your lordship, my lord?
Yes, Mr. Kalyan, yeah.
My lord, kindly, just one thing. This is the incident which has happened. It is extremely shocking. Nobody is supporting that, and whether it has been who has done it, all steps should be taken against them. There is no difficulty.
Whosoever
But
they
one
were-
thing is this, my lord. I want to take
Very easy to deny and denounce it after.
Yes, my lords.
one thing, Mr.
Now-
Mehta.
now
I am
everybody wants
kindly,
to- now
Mr.
everybody
Mehta.
wants to
No,
play
Mr.
saint.
Mehta.
Now everybody wants to
My
play
lord, now
saint.
after 15, my lord, after 15, they almost everything has been taken away by the election commission. Therefore, kindly, therefore, if your lordship make
These
responsible
very
to the state
persons have
government, it's
gone
all right.
My
But the
lords,
election,
my
please,
lords, that's the
please,
sinister plan.
this is
These
because
very
of the
persons-
provocation of the election.
My lords, these very persons have filed bills before the Honorable High Court of Calcutta. They have challenged the
That's why we
transfer
are-
Every
orders.
day, election
They called the
commissioner is
Lane
making
Election
provocative
Commission.
statement.
My lords, when
Every day,
When the
election
Sum and
commission,
substance of the state is,
when the Honorable
the
High Court
state's
of
answer is
No,
that
Mr.
except
Naidu.
5
No,
officials,
you
the
are
rest
in
of the
charge.
officials
If
of the
there is
same
a
cadre
failure,
are useless
if
and
there is a
ineffective.
failure,
Cannot run
Lord,
the
if there is a
administration
failure
without
on the
those
part
criteria.
of law and order, this is a failure on the part of the election commission. They have chosen their own man
These
and
are the-
shifted.
These are the
This is a
rabble
failure
rousers.
part of the
These
election
are the
commission.
rabble rousers who
Don't
have
say,
instigated the
Mr.
mob.
Naidu,
They
yes,
have instigated the
most-
mob
no,
and
no,
created
this is election
situation.
commission.
Just
Chief
because,
election commissioner has
just
taken it
because-
personally.
just
My lord
because
is
the
saying
Honorable
that
Court
why
said,
West Bengal?
Now
Because
it's
chief
over
election
now.
commissioner has taken it personally.
just because the Honorable Court has not yielded to their illegal demands, they wanted to demonstrate that they could do anything, even under the gaze of your
Don't
lordships.
tell Mr.
This
Naidu.
is what they have
We
done
are
it.
not like you.
I know.
We are not like you. We are not like you.
Obligement.
Obliged. Grateful, my lords.
Chaliye.
Lord, may I mention a matter of a very senior JAG officer, my Lord, about whom there was a review judgment in which her reinstatement had been ordered. Your Lordship had said that it should be listed when the case was listed last on the 9th.
No, that was to await for the,
Yeah, that judgment has come.
so
So your Lordship may kindly list that matter.
now it
My
will
lord,
probably
On
fall
any
in the-
miscellaneous.
My lords, may I make a mention in grave and extraordinary circumstances, my lords? We are for Rajasthan Hockey Association by the order of Rajasthan Hockey Association, my lords.
Okay,
By the order of Rajasthan High Court dated 24th March, my lords, we have sent 12 to 13 years of boys and girls to national tournament, my lords. Abruptly, yesterday, they passed a modification order, modifying the entire order and asking those players to be on road without shelter, without basic facility, my lords.
no.
But this extreme urgent situation, my lords, they've been asked to leave the premises and they went to Bihar and Jharkhand, my lords.
Let it be, we can't do anything.
My lords, making a mention for today, my
With your lordship's permission, may I mention a matter which was listed last Wednesday, my lords? It was adjourned, my lords, and a date has been fixed, because of which I am unable to.
Waste our time, we can give in writing to the registrar. Next item.
Lords, listed mentioning is not permitted, my lords, because a specific date has been.
Item-
I'll give it.
Lords, may I mention?
Please, Lord.
Please, my lords, may I mention a matter? It is regarding an anticipatory bail dismissal. It has been dismissed on 24th of March 2026. The defects have been cured, and the 3 days these are holidays. Can it be listed on 6th of April?
Which item, madam, you are talking?
Yeah,
We thought you are arguing item number 1.
your
Not
lord,
argue item number 1.
No, Your Lordship, I'm mentioning a matter.
No mentioning,
All right.
mentioning closed.
All right.
Item number 1.
Your Lordship, I'm appearing for the petitioner in the matter. I was granted bail by white order dated 8/9/2023. However, which was cancelled with
There is clear misuse of.
Lordship, this is a case, Your Lordship, that on his undertaking, the High Court granted him a privilege of
Have you seen it? This is the order in life that he will keep with dignity.
No, no, yes, Your Lordship.
वो लड़ रहे हैं आपको
I-
सरकार
That
की-
is, that is some issue. Your
I am
Lordship.
appealing for the wife, Your Lordships,
Just
that
there's no counter on the behalf of the wife. Your
had
Lordship.
he some issue, Your Lordship, he could have applied to the court that I am not able to
So he
perform
has
the
an
undertaking
intimate-
which I have given to the court. Now the undertaking of
Just
the
a minute,
property,
just a
Your
minute.
Lordship,
I am the wife, I am suffering, I am not able to
Your
speak.
Lordship, there's no reply.
I have been-
Counter affidavit which has been filed by the respondent number 2.
He-
However, they have been given the last opportunity as well.
When?
First bail was granted on 8/9/2023, my lord,
23, Your Lord.
which was cancelled by impugned order dated 4/4/2025. However, in between the charge.
No, you are on bail since 8 September 23.
Yes, Your Lord.
23 to 25 interim bail. Cancelled, then it has been stayed. Wait.
The bail was granted on
Bail-
undertaking, Lordships.
Forget undertaking. What
Why I went back? Because there were again
court order cannot
coming
force
from her.
parties to
I have
together.
rented
That's-
apartment in
Please work
Patna,
out
put her
something
away
with
from my
the
family so
husband.
that we can have
Which can
proper-
have some dignity.
Please have patience.
That's, I agree, Your Lordship.
Some dignity.
Even I bow down to Your Lordships, I have tried my level
What
best.
is doing? What does he do?
I am a professional who is working outside India, Your Lordship. I have
Earlier he was in
to
Saudi.
Patna, Saudi Arabia. I have shifted because of her behavior. She was of opinion that I should work in the hometown.
When was the marriage performed?
Your Lordship, marriage.
16.
17 4 6.
Yes, Your Lordship.
You should have young lawyer, you should have everything on tips. Why do you open paper book for this?
Just wanted to.
You never did it in life.
I
You
apologize.
should have remembered immediately. How many children?
So there's no children.
There is no child.
He has forced for abortion, Your Lordships, in Saudi itself.
So like
No, Lordship, there's
issue notice, then say accept notice on behalf of.
Notice was already,
notice already
Notice was issued the
was
court.
already issued.
It's already issued.
State has filed its reply, Your Lordship. State has filed its reply.
Who has not filed?
Condition, that's it.
All it.
Even if Your Lordships may appropriate, that send it to mediation, I am even ready to cooperate and that settle out everything.
Say leave granted, the appellant husband is agreed by the order dated 4th April 2025, passed by the High Court of Jharkhand, hereby anticipatory bail granted to him earlier by an order dated 8 September 2023 for my husband health. Next one, the appellant and respondent 2 got married on 17th April 2016 as per Sharia law. There arose some matrimonial dispute between the parties, which compelled respondent 2 wife to lodge FIR number 09/2023 dated 9th March 2023 under section 498A, 341, 323, 379, 506, 34 IPC and sections 3 and 4 of the Dowry Prohibition Act 1961. At this station will be the appellant and his family members were arraigned as accused. Next paragraph. Apprehending arrest for the appellant and his co-accused filed at least 20 bail applications, which were rejected by the Sessions Court on 22nd June 2023. Still aggrieved, the appellant approached the High Court through ABA number 6374/2023,
Please,
in which he was granted
anticipate.
pre-arrest bail, while order dated 8 September 2023, on the ground that subject to the condition that inverted commas, he will keep and maintain verse number 2 with full honor and dignity as his lawful wife. Full stop, inverted commas closed. Next paragraph. It is hardly in dispute that the appellant broke furnished bail bonds and took his wife with him to a rented accommodation, but soon thereafter he left her to her parents' home, abandoned. As the appellant failed to honor the undertaking given before the High Court, as per number 2 wife filed CRMP number 3943 of 2023 before the High Court, seeking cancellation of the anticipatory bail granted to the appellant, while order dated 8 September 2023. The High Court has, while informed order, allowed that application holding that the appellant has committed fraud upon the court with the dishonest intention and misleading the court by making a false undertaking that he will keep and maintain his wife with full honor and dignity. Next paragraph. The aggrieved appellant approached this court and while order dated so and so, he was granted protection against arrest. Next
the cancellation of protection.
There is no.
And his admission is there on the impugn order page 2 that he is not willing to underbuy by the undertaking, Your Lordship. His statement of the petitioner is there on page 2 of the impugn order that he is not able to abide by the undertaking, Your Lordship.
As the facts would speak for themselves, the appellant made a false statement before the High Court that he would keep his wife with him with
page 2 detail on
with full honor and dignity. He later on resigned from that undertaking, obviously for the reason that due to unfortunate marital dispute, the parties are apparently are unable to be together. Next slide. What is the status of the investigation?
Charge sheet is filed, charges is to be paid.
It is not in dispute that
12 witnesses
is complete and charge sheet has already been filed. The custodial, the judicial custody of if the appellant is kept in judicial custody which serve no purpose. It would rather bring more hostility between the parties, leaving no scope of future reconciliation. Next, contrary to it, it seems to us that husband to wife deserves to be awarded suitable maintenance to ensure that she can be a dignified and respectable life. Consequently, we allow this appeal, set aside the impugn order and restore the pre-arrest bail granted to the appellant and the subject FIR, subject to the condition that The appellant shall be liable to pay a sum of 30,000 as interim maintenance to corresponding to wife on or before 10th day of the calendar month. While the appellant shall be liable to pay interim maintenance as directed above with effect from 1st September 2023, namely the month in which he obtained anticipatory bail order, pre-arrest bail order by making a false statement before the High Court. 3. The arrears of interim maintenance shall be paid by the appellant within a period of 3 months, within a period of 4 months, within a period of 4 months in 4 equal installments. However, he shall continue to pay the monthly maintenance on or before 10th day of the calendar month. Calendar month. Next paragraph. In case the appellant fails to comply with the directions, comma, the extent of which that is deemed to have been dismissed. In that event, in High Court, the Chief Judicial Magistrate Guilty is directed to take all lawful coercive measures, including attachment of the property of the appellant or his family members, and if so required, such property shall be auctioned to recover the arrears of money.
And the protection of any harassment, if you observe one line.
Next paragraph. It is clarified that we have not expressed any opinion on merits of the allegations and counter allegations. The law will take its own way.
Much obliged.
Yes, Lordships. And 2.5 years in custody, Lordships. All the family members have been granted bail, Lordship. Page 20, para 10.
How many witnesses examined?
7, Your Worship. So far, 7 witnesses have been examined. I'm for the state, Your Lordship.
7.
7 out of 34.
How many total?
34, Your Lordship. So within 6 years, Your Lordship, she has committed suicide.
More than a year.
Within 6
There
months.
are within 6 months, and there are chats between the brother and the deceased, Your Lordship, signifying that he has been.
But the suicide is at the parental home.
Your Lordship.
Then more than a year.
It's a very serious matter, Your Lordship, and 5 times bail has been rejected, Your Lordship.
Witnesses, all crucial witnesses have been examined.
Lordship. They have supported the prosecution's case, Your Lordship.
The appellant seeks enlargement. The appellant
May just make submission. There is possibility that.
in apply number 483/2023. So and so. Section so and so. That is 2nd September 2023. Under section 498A304B and 34 IPC. Registered Administration Hazira, District Wadi. The appellant is the husband. The deceased wife unfortunately died an unnatural death within 6 months of her marriage. from on 4th August 2020. The appellant was arrested on 19th December 2020, on 24th September 2023, and is in custody since then. The other family members who were also arrested have since been enlarged on bail. As per the plan, State Council points out that 7 vital witnesses have already been examined, though the prosecution proposed to examine 34 witnesses. The conclusion of trial will just take some time. The appellant is in custody for more than 1.5 years. More than 1.5 years. No useful purpose shall be served by keeping him in custody.
23 actually 2 years. 2 years and
12. The further detention of the appellant will serve no purpose. Taking into consideration the case already spent, and because that conclusion of trial will take some reasonable time, or without expressing any opinion on merits from other standpoints in the law, the appellant is directed to release on bail's checklist permission for
I'm highly obliged. If this matter bail has already been granted by this honorable court on 31/2026, only it has to be disposed of.
Nothing.
I am deeply obliged.
In item 4.
Item 5.
Wait. It's the connected matter from against the same impugned order was listed yesterday before court 7 minutes. Connected matter minutes from the same impugned order was listed yesterday minutes before court 7. Lordships have been pleased to issue notice. I'm praying this may be tagged along with this. There are 2 verticals from the impugned order. One is the bail cancellation. Second is where I challenge the concession granted of the status of an approver to the co-accused.
They are completely different premises.
Yes, minutes.
Why should the bail be cancelled and how are you interested in cancellation?
Permit me to assist your lordships on that.
Grant of pardon is a relevant fact for the purpose of your implication.
Minutes.
Why should bail be cancelled?
3064B, if your lordships will have for it.
Those are.
If the Malats, there are 2 routes available, Malats, either under section 64.
Of all arguments, we are saying under Article 136 at the behest of a co-accused, why should we interfere with a bail, even if it is illegally granted?
Your lordships may not issue notice, your lordships may simply tag with it that matter.
No, that issued by whom?
That is by me only.
Hello.
Minutes.
The ground for you to challenge whether 306 was fairly utilized to implicate your clients.
Minutes.
Even if the bail is
permit me to
granted
explain what my argument is.
Subsection 4 of
I completely follow that, Malas, but my argument is twofold. Either Malas 306 will have to be followed or 64 will have to be followed.
Again, we are telling you this is definitely a legal nicety, but we will not take cognizance of it at the behest of a court.
Your lordships may not then issue notice, your lordships may simply keep it with that matter. Otherwise, dismissal of this may come in the way in that matter.
That this order will not have any bearing. We will not.
Very.
There is no ground to interfere with the order. 28th January 2026, whereby the High Court of India is coming to on regular bail. However, the grant of bail and or affirmation of that order by this court shall have no bearing on the questions initiated by the petitioner
Challenging the
on the merits of the petition filed by the petitioner challenging the pardon granted to respondent. That matter shall be decided as per its own merit.
Indeed.
Obliged.
I understand, my lords, because yeah, grateful.
My lord, it's a case of suspension of sentence. My lord, the prisoner has already undergone more than 5 years of actual jail sentence and 6 years with remission. My lord, he has no criminal antecedent. The appeal.
4-year-old child. 4-year-old child.
Yes.
You are sentenced to life imprisonment.
Yes.
So why 5 years you will get suspended?
There will be question after 4 years, 5 years in a life imprisonment. No case to suspend the sentence at this stage is made out.
My lord, then.
However, the petitioner shall be at liberty to apply before the High Court at an appropriate stage.
Serial number 7. This is for regular bail. The petitioner is behind bars since last 2 years, my lord. Not even first witness examination in chief is complete. But only fact is that test identification per 2 witnesses have allegedly identified me. But the test identification is not legally admissible. My lord, I am only 12th pass out agriculture. Those who are in knowledge of making bomb have been considered by the Honorable Gujarat High Court, my lord. And my lord, it is simply an allegation. Even wife has also said that his thought process was that he could have done it, but there is no motive. It is a conjecture, my lord. And in TI parade, the witness was shown. Please, your lordship. I may serve it through, my lord, concerned council, state council.
Next item.
Most grateful.
Please, your lordships. My lords, this is an SLP arising out of rejection of regular bail, my lords. At the outset, I must point out, after the rejection of the first regular bail application, my lords, there was a settlement between the accused and the complainant, my lords, after which a second bail application was filed on that basis. However, my lords, he resigned from the settlement, so I withdrew that bail application. So presently, I am against the first bail application order, my lords, which is on merits. My lords,
of granting them,
my lords, the amount in... My lords, almost 11 months I've spent. My lords, the allegation is of 420 and 66 DITI. My lords, the maximum under...
We are not on that, the provisions which you are referring to. We are only on the concern substance of the allegation.
Let's let him deposit.
Plus, the allegation is that he has been defrauded of 3,30,000.
Relax.
My lords.
Deposit that amount.
My lords, the allegation as per the charge sheet is that out of the 6.5 lakh, 3,30,000 has gone in the account of one Laju and Gali. That account is somehow related to me, not the entire.
You want 6.5 lakhs deposit, you get your pay.
No, my lords, what I'm trying to say, the allegation is vis-a-vis. All I'm saying is the allegation vis-a-vis me is of 3,30,000. Plus, what I'm trying to point out is the allegation vis-a-vis me as per the charge sheet is regarding 3,30,000, my lord.
You want to dismiss or you want?
My lords may kindly then...
No case to grant bail at this stage without dismissal.
My lords may, all I'm saying is instead of 6,50,000, let me deposit 3,30,000, my lords. The allegation is not for 6,50,000.
No case to release the petitioner on bail at this stage without dismissal. He will be at liberty to apply after 6 months.
My lords, in that event, my lords may permit me to withdraw, my lords, because I won't get bail in the High Court then if there's a dismissal here. I've spent almost 1 year, my lords. This is a case of...
Sooner we were dismissing this petition on merits with the direction that he will not apply for bail for 6 months. Let me counsel for the petition, seeks and permitted to withdraw the petition. So, kya kaun sa order lena hai?
My lords, one suggestion. My lords, it very fairly fell from the court. If I deposit the amount involved, my lords will issue notice. All I'm saying is that the...
withdrawn at this stage.
My lords, the allegation is that 3,30,000 is what is attributed to.
The question of 3 lakh or 6 lakh. Question is of conduct of a person. He has a criminal instinct. He is a cyber criminal.
I have disclosed that.
This kind of person, the jail should nowadays be kept only for them. The murderer, the other, these can be released, they can be reformed. These cyber criminals, they must not be spared.
In that event,
They should be kept in that single cell and without any, no possibility of any mobile or anything. That's the only way to deal with these.
I understand what's following, my lords. My lords, the initial offer of 6,50,000 which my lords were giving.
We are not backwards. It's like no amount.
If I may just confer with his parents who are out here, my lords, all I'm saying, there's some financial difficulty.
This person, this complainant, he is harassing like anything. He is entering into settlement, then walking out. Earlier also you have duped many people.
My lords,
it's not the question of one amount.
in that event, my lords may just allow.
The moment you will be out again, you will start doing it.
My lord may pass it over. I'll just seek instructions if 6,50,000 can be arranged. The parents are in some financial.
Both the dismissal withdrawn with liberty to the petition to move before the High Court on the basis of the provided that he agrees to the settlement which he had earlier made with the complainant. There you are.
My lords may allow us to give appearance physically, my lord.
Grateful.
Yes, 9.
My lord, I am appearing for the applicant. My lord, the contraband substance was seized on 3rd February 3rd December 2024, my lord. I was summoned in Bangalore. This was seized in Ahmedabad, my lord. I was summoned in Bangalore, my lord. On 7th, when I went to the NCB office, I was arrested, my lord. The allegation against me is that, my lord, I have booked one consignment to USA. My lord, nothing, no conscious possession, nothing is recovered from me, my lord. For last 16 months, I am in jail, my lord. Charge sheet is filed, trial will take time, my lord. And my lord, other 2 accused have already granted bail, my lord. Who are the main accused, my lord? The allegation against. My lord, can I just say, show only one line, my lord? My lord, what I am saying, my lord, there are 2 other accused. My lord, may see what they are talking about their bail, my lord. They have given me, as per the allegation, they have given me something which I tried to send it to USA, my lord. My lord, at page number, my lord, may see what is the allegation against them.
In a different city, you go to Ahmedabad to book an consignment to US, and that.
My lord, there is no evidence to that effect, my lord. Even CCTV is not there, my lord.
The courier's officer, Ravi, does not identify you by picture.
My lord, he has identified me, my lord.
You want,
my lord, subject to trial, this, my lord.
We are not hearing your conviction, right?
My lord, that's what I am saying, my lord. So, my lord, it's a 16 months. I mean, my lord, put any condition, my lord, notice me. My lord, then, my lord, may expedite the trial, my lord. I am saying there is no evidence, my lord, day-to-day trial as per the
trial court shall make an endeavor to conclude the trial as is.
Deeply obliged, my lord.
Please, lords. Petitioner, my lord, is a 22-year-old student. Lords, his mistake is that he was traveling that vehicle, my lord.
Only difference is you have no antecedent.
My lord, there are 2 vehicles.
You have no antecedent. 2,000 kilos of gasoline.
My lords, there are two vehicles. The vehicle in which the petitioner was traveling. The petitioner, the vehicle in which was traveling, my lords, High Court, where it has heard is, my lords, High Court has taken his case. My lords, my lords, there are 2 vehicles. Lords, there are 2 vehicles. But he's a student, my lords. There are 2 vehicles, my lords. His first vehicle, my lords.
Withdraw this.
My lords, in fact, there's another issue, my lords, that the incomplete FSL report, my lords, that was, my lords, that was also there, my lords. High Court has not.
Tell us that in Ganga this much quantity.
My lords, in fact, the vehicle in which he was traveling, my lords, was only 80 kilos, my lords, and he was an occupant. He did not flee from the spot. The driver of the vehicle fled from the spot. The other vehicle, my lords, the other occupants. Withdrawn, my lords, permitted to withdraw, my lords. My lords, to renew that liberty, my lords, granted liberty to renew that prayer before the High Court. Because the final charge sheet is not yet submitted, my lords.
How the trial court will make an endeavor to conclude the trial expedition.
The trial is not yet started, my lords. The investigation is still ongoing, my lords. The trial is not yet started.
10 months?
1 year.
10 months, my lords, he's been in custody. My lords, he is a student, my lords. That's
all. Next, item 11.
Well, it's in item 11. The petitioner has been incarcerated for more than 3 years now, Millets.
Because I believe that there are antecedents, my lord.
Which state you have not operated?
Well, I understand that.
Operated in Goa, in Andhra Pradesh,
I bow down.
Tamil Nadu, in Karnataka.
But I'm only requesting your lordships for
You are
a.
right now only national player, that must be your regret.
एक international गया, अब national.
But it's a small direction that a trial may be completed in a time bound manner. I've been inside for 3 years, my lords.
पूरा साउथ तो कैप्चर हो ही आपका. Madurai, no case to grant bail at this stage.
I'm grateful.
But the lady is in custody now, all others are on bail. The allegation is not that the whole amount was not taken, etc.
ये पहली बार आपकी स्पाई थी थे.
But then I'll just tell you, but just have a look at this chart. Just look at that chart. Everybody else is on bail. Everybody else is on bail, not except for her. And she is in custody.
Everybody is there, but she is the ringleader.
Yes, but the only thing is not today she's in custody with her minor child. And the issue is regarding that so-called conversation with her brother-in-law. Not really, nothing may turn on that. That's the only thing really against her. Grateful. Deeply blessed.
My lord, this is regular bail. I'm in prison for almost an year, my lord. I'm in prison for almost an year, my lord. My lord, nothing was recovered from me. The forged document which has been alleged has not been recovered for me. This is a magistrate travel, my lord. 22 witnesses are there, my lord. Okay.
Concurrent finding reversed to the second appeal stage, my lord. But on, he admits that, my lord, the purchaser, subsequent purchaser knows about the OT in my favor. He knows that he is in possession of property. In spite of it, he purchases the property, my lord. And my lord, delay in refiling will be condoned.
Because I appear on caveat, my lords, on behalf of the defendant number 2, my lords, respondent number 1 here, my lords.
Delay will be condoned. Delay in refiling will be.
Respondent number 1, defendant number 2, my lords. Original defendant number 2, my lords, the purchaser. This is a clear finding that it is a collusive suit, my lords. After selling it to me, 2 days thereafter, there is a legal notice, my lords. They say that entire consideration.
You see, the High Court has reversed concurrent finding of 2 courts.
Yes.
Delay in refiling will be.
Request for returnable date, my lords. That's it.
Within 4 weeks, post the matter for total consideration and so on so forth.
The delay in refiling will be. Delay in refiling will be. Will they say delay in?
Item 15.
In this, I want to see these dates for a minute and I'll make a suggestion immediately after the dates. I'll make a suggestion.
So how can you, after so many years?
No, Wallace, this sounds delayed, but Wallace, that is not so. Just give me a minute. Now, Wallace, there were 3 issues. So, first issue was encroachment, right, Wallace? Just turn to 2 dates, Wallace. Number 9. It sounds bad. It is not like that. Just give me a minute. 9. The other side accepts that the encroachment has been removed, right, Wallace? Then in item 18, which is as recently as 3/5/24, on the ADM report, this is very, very important, item 18. ADM report notes that encroachment are present. They say, however, to give now will be a loss to the exchequer. I'm going to make a suggestion on that one. So encroachments are there, admitted by the other side at page 99 to 101 at item 18. The second issue was litigation pending. That is, just turn to number 6.
Who told you to purchase it then?
I beg what?
Why did you participate in it?
No, this came to knowledge later on. It's filed later. Just see this. Just see this. It's filed later.
Dr. Singh, there are professional auction purchasers who has only exclusive this dhanda. You go, be the highest bidder or the lowest L1, and then start blackmailing the world.
So I am at pains to show that I'm not that category. Just so I've shown an encroachment. It's your admission. It's the respondent's admission. Now come to Wallace 6. No, time Wallace, now just see 6. That admission I showed was 2024. Now come to number 6, Wallace. This suit is filed, and most important is Wallace, number 12. A stay is granted by the rival auction purchase. The predecessor, Wallace, the previous chap went out.
Dr. Singh, the suit is dismissed in 2004.
No, that's right. That's
from 2004 to 2022.
Number 4.
Just because a step is pending, you don't take any steps.
Well,
And then when in 22 it is dismissed, you make a representation.
Yes.
And they say that you pay this amount as with the interest. You say that because of my deposit earlier, I would not be.
That's where my suggestion. So 2 minutes. So 2 minutes. 2 minutes. Your lordship's query is number 13. Just give me a minute, please. 13. The appeal is filed and it dismissed only on 16. It's dismissed on 16, 22. I make the offer. Maybe I made a mistake saying the old one only. I am saying that I will pay the current market price. With that escalation of my money also which is lying, you can adjust it.
So you participate in tender, fresh tender, fresh auction. If someone pays a better market price, why won't they?
Whereas they are themselves.
Just you are entitled to
Number 18 is saying it's a delayed market price should be higher. I'm prepared to pay the market price. Obliged. Deeply obliged.
Supreme Court is null. No.
So I am seeking leave to appeal against order of High Court in 3089. Order passed on 2011 to 2025. The Honorable Court refused to exercise.
I could give him maximum.
So the
suit in High Court, that Supreme Court judgment will declare null and void. Who is advising you? Who drafted this petition for you?
Myself, sir.
From where you learned this language?
So I just read the books and.
Right now, the petitioner is indulging in filing false, frivolous, scandalous, and baseless petition. He is clearly abusing process of law. He is directed to deposit a sum of his 10 lakh as cost. There shall be a further direction to all the courts not to entertain any petition on his behalf.
Your Lordship, allow me to submit something, sir.
You can file any kind of frivolous cases, blackmail or of highest order.
Sir, the order was passed against me without against a deceased person. So that was a nullity order.
The Supreme Court order there.
Yes, that was against a deceased person.
All right, thank you very much. Leave it. Right on the petitioner appears to be a blackmailer who is abusing the judicial platform for gaining for the purpose of dishonest and undue claims. He has gone to the extent of challenging a Supreme Court judgment before seeking its nullity before the High Court.
So, Your Lordship, I'm sorry
His
for
claims.
sorry
His
for
claims are ex facie false, dishonest, and untenable. While dismissing the petition, we warn him that in case he is found further involved in abusing the process of law, the court's consent shall be are directed to impose exemplary cost on him.
Your Lordship,
Exemplary cost on him.
Lordship, I'm sorry for what has happened. I have submitted. I am partying person, and this petition was passed against on the basis of.
This is what the people, when file in person, they misuse the provision.
No, so this case against was passed again on the.
Don't indulge in frivolous kind of litigation.
Fabricated document, sir. And it was passed against a deceased order, a deceased person.
We have today advised you and warned you both. Now, in case you file any such petition, there will be very serious consequences.
So, but the order is a nullity, sir.
Right? Let it be nullity.
So,
Next slide.
sorry if I am expecting something else to the law.
That is not the way to file litigation. Don't file frivolous claim with given impression that you are a dishonest person. You have already got more than what you deserve.
There is not a single.
All right, thank you very much. Thank you.
So, I have done some dishonest thing.
Thank you. Item 17. Yes.
So far as the initial 34 petition was concerned.
Sorry for that, sir.
It's all right.
So initial filing of 34 petition was well within time, Your Lordships. Now it was filed before the wrong forum. Initially, the 34 petition which we have filed.
Tell us why you took 3 months more in filing the press.
Well, right now I may not be able to give that reason because one of the reason was the advocate concern was not well. He was very old advocate who was engaged. But my lords,
that is the only reason
no,
that's stuck in our mind.
But my lords, my submission is slightly different, Your Lordships. What I am submitting is that the Honorable High Court has failed to appreciate the impact of Order 7 Rule 10A to this proceedings, Your Lordship. Because my lords are aware, Order 7 Rule 10 clearly says if the proceedings are filed before the wrong forum, the plaint has to be returned. Now 10A specifically says that the concerned court has got a power to fix the date before the subsequent court which is having jurisdiction. That has been totally missed out because once we take into consideration that particular aspect, the limitation aspect will not even come because then the original petition was well within time, Your Lordship. High Court has totally missed that particular Order 7 Rule 10 as well as 10A.
Order 7 Rule 10 does not apply to a Section 34 application.
But it is.
Can there be a Section 5 to a plaint?
There is no Section 5.
That is
Absolutely.
why Order 7 Rule 10A.
So,
why we are asking the question is Order 7 Rule 10A is because there is no Section 5 to a plaint, and when someone by a bona fide mistake takes out an application, institutes a suit, he is returned directed to be filed within a time frame. If he fails, he fails. And here what has happened? You've already taken 90 days to file your first Section 34 in a wrong court.
Yes.
Now within that time which was required to be filed, you at best have 30 days, that extra grace of 120.
With due respect to Your Lordship, this is what this Honorable Court in Northern Plastic has said, that 34(3) limitation will apply only to the initial date of filing of the Section 34 petition, not subsequent. So at the most can be treated as a refiling.
If that is so, then Section 14 doesn't come to your aid at all.
My respectful submission is that
you are gone.
Absolutely, 14 will not even.
If you are relying on Northern Railways, then you have no case. You have no case.
Northern Railways,
you are arguing the other way.
No, may I just show Northern Railways, Your Lordship? Because though Northern Railway was a matter,
it's a different case. That's why we are saying in Northern Railway, the case is one of condonation. And here is a case where you are filed in a wrong court.
Yes.
You are filing afresh. Section 14 would certainly come to your aid. Calculating Section 14 and extending that portion. You had only 30 days left and you filed it after 3 months. And you are saying that the limitation is going to run from that day.
This is exactly what the High Court has held.
That's according to us.
You spoiled your case when on 15th March 23.
They had given you the opportunity. You should have go and file it.
Difficult because the thing, I cannot challenge that award because of this limitation aspect.
But the problem now, nobody can condone this.
You can't condone even under Article 1.
And in fact, my lords,
we have held on Article 142 also. We cannot condone the bar of 35.
Because in fact, the award itself was ex officio illegal.
You should have asked Rohini Court, please return my plaint. That now you are advising me to go to the correct court. You return my plaint, and the very next day you could file it.
Because the arbitrator himself in this case was ex-employee of Delhi Metro Rail Corporation. So the award itself is totally.
Sir, on merit question of examining will come only when the suit is maintainable.
I'm just requesting my lord.
That is the problem.
Please. My lord, this is an SLP against an 11-5 order. I am cognizant of the delay, and I must point out at the outset that we have participated in the arbitration, filed a section 16 which was rejected. However, my lords, I will just point out two things and thereafter leave it to my lords. My lords, the
Extent that this arbitration proceeding should not have any impact on the criminal prosecution.
Lordship.
Then it's all right.
My lords, my lords may permit me to make two submissions because it is our submission that this arbitration itself is illegal, my lords, as we pointed out before the Honorable High Court. The contract, my lords, got over in 2021, and that is the point at which the arbitration clause ends. There is no arbitration agreement post that. It was the assertion of the respondent that there was some oral contract which continued after that, which was specifically denied in our counter. However, by way of the impugned order, the Honorable High Court says, no, you have not denied in your counter. Hence, the oral agreement is accepted. Hence, an arbitration agreement is read into it. My lords, I will point out that in our counter, we had specifically said that the arbitration agreement came to an end in 21. My lords, there's two caveats.
So also good. While further arbitration proceedings will remain slow.
My lords, delay. No, my lords may condone the delay.
That's why we are. You are also coming leisurely after 1 year.
My lords, I am cognizant.
You started on foot from Vizag or from Vijayawada or from renewal.
My lords.
Notice condonation of delay करने भाई. Notice तीसरी condonation of delay, notice SLP, notice criminal prosecution, notice.
Most obliged, my lords.
Please, Your Lordship. Appearing in item 19, my lords, this is the miscellaneous application. There was a typographical error, my lords, but that petition was filed by the.
In all fairness, we should post this matter before Justice Narasimhan.
Please, Your Lord.
It doesn't look right. If there is a mistake, then mistake is only of number.
Mahadevan, my lords.
Mistake is only of number.
Mistake is only of the number, my lords.
So let them be correct.
That's the nomenclature. No, my lords, that part. No, mistake is on the part of the petitioner. I am the respondent husband, my lords. My lords has dealt with the first date, and my lords, Justice Pancholi has dealt with Justice Mahadevan on second date, my lords, when this order was passed, my lords.
All right. Oh, my brother was there. That's why they said it. This one. Objection to GP 12 of 2005.
My lords, may I say, my lords, in para 7, my lords has pointed out for the expeditious disposal. Can it be, my lords, made time bound, my lords, because 2 months has since passed, my lords? If I may request, my lords, please, your lordship. Great. So grateful, man. Highly appraised.
Lord, the difficulty is that, my lord, the judgment squarely covers, my lord, the three judge, which, my lord, in fact, I was also party there. Now, my lord, what is disturbing is two, my lord. The impression which is coming from the impugned order to your lordships is that the, my lord, the finding. Now look at it. Ironically, page 40 is the first finding which starts. The finding says I have looked at the documents, no reasons given, and explanation rejected.
We understand everything. When the books of accounts of the company shows a price,
yes, my lord.
Invoice shows a price.
That's right.
It start to the replacement part.
Yes, my lord.
Then it will squarely fall within the Tata Motors judgment.
That's right, my lord. Yes, I'm grateful. So therefore, your lordship said in Tata Motors 3 judge that the accounting entry which is to be made is only for the purposes of provisioning. Now we are following that. That is what the High Court is, my lord. Lordships are absolutely right. The Honorable High Court completely misses.
There was nothing to show that there is no credit note raised. On the other hand, there is an accounting. The invoices show a price.
My lord, the invoices show the warrant. My lord,
warranty invoices show the price of the replacement.
My lord, two things. No, my lord, with the utmost respect. Three judge bench, my lord, lordship may bear with me for a moment, my lord, the difficulty is this wise. My previous, my lord, assessment years.
The best argument you had. 2007, 2008, you were given the exemption that this is not a sale. And that has been accepted. But later on
also given.
Later on, relying on Mohammed Ikram and Tata Motors, the findings have been recorded.
No, my lord, with utmost respect. My lord, that is where, my lord, lordship may give me one window to convince your lordship. My lord, I never insist, my lord, this one, my lord, please give me one window, my lord. My lord, lordships may see the Tata Motors, because, my lord, I was party there. That's what lordships are right. Let me just articulate what happened in Tata Motors. The Tata Motors judgment, my lord, said that whenever there is nothing on record to show any consideration, if the dealer is giving and that part is utilized for, my lord, replacement, then there is no consideration which is there. Now, what is being put against me on the basis of what the High Court erroneously records, your lordships, and it gives that impression, to be fair, says that you have done accounting entry. That's what is troubling your lordship. Now, my lord, the accounting entry is mandated under the income tax, because your lordship may see, my lord, that's what I wanted your lordship's consideration. What has happened is three things lordship may bear in mind. The accounting entry under the accounting standards has to be made, because your lordship will see what happens when I first time sell my lord, equipment. It has warranty, lordships are aware. That warranty, my lord, has to be accounted in the provisions of my balance sheet. That is exactly what I have done.
What happens in a warranty?
Yes,
the sale price actually incorporates the warranty expenses.
Lordships are absolutely right.
The supply to the purchaser
right.
on a warranty of replacement
yes.
does not have the money or the sale of transfer of the sale price from the purchaser.
Absolutely.
It is the transfer
that portion
price between your dealer and yourself. And that is why you give the dealer a credit note. And for that purposes, both the invoice and the accounting entries indicate the price which you are to credit to the dealer.
My lord, that's what I'm saying. My lord, that is not, my lord, why, my lord, give me that, my lord, the High Court doesn't go into this aspect. The Honorable High Court doesn't go into this aspect at all, my lords. The High Court, my lord, the accounting...
Allow you to open this question up.
My lord, with utmost respect, my lord, the accounting entry, if that is the basis, my lord, then this will become completely wrong for all manufacturers. The accounting entry is mandated, my lord. With utmost respect, the accounting entry under income tax is mandated.
Sir, the tribunals as well as the First Appellate Authority has looked into the invoices. The invoices against which the supplies were made, where price has been specifically quoted.
My lord,
there is a categorical finding of passing of the consideration. That's why Tata Motor doesn't apply.
My lord, that is what, my lord, if the authorities are now going to go on assumed basis, my lord, what will the assessee do? My lord, that is what something which had to be rectified.
You had the duty, sir, to have your dealer file an affidavit or a letter that they have not raised any credit note.
My lord,
That must
my
be
lord,
done categorically finding that you have not
my
done.
lord, why, my lord, every pleading has been stated that not a single penny has been taken. That's why I'm saying, my lord, some judgment of your lordships is to be, my lord, not followed in this manner. What impression will come? And my lord, this is the same position in subsequent years because your lordships put it to me. The same position is being followed in subsequent years. Just because of whims and fancies of the authority, my lord, and look at the irony. The original assessment order, no reasons given at page 40. And then you build up a reason, my lord, which is unheard of. The authorities did not even remain present before the first appellate authority. And your lordships are putting only the invoice. The invoice is mandated even for warranty. You have to show the original embedded part. That is what I've shown, my lord. There is no my lord, sometimes, my lord, the difficulties, my lord, if you are wrong, I understand. But here, my lord, let me convince your lordship that the invoice is showing price. It is written, my lord, warranty.
We won't allow you to open these questions again.
My lord, but this is, my lord, if whatever three things your lordship said, I am, my lord, demonstrating not by asking your lordships to show something new, but what is there, my lord, at least that should have, my lord, appealed to your lordships to some extent, my lord. Sometimes, my lord, in this matter, I really felt that the authority has really, my lord, gone beyond, my lord. No reasons at page 40. First appellate court out of the blue, my lord, says that this invoice is showing invoice, therefore, contrary, my lord, it will be taken. And that, my lord, that assessment, that order of, my lord,
appellate court, you go to the tribunal, you do not challenge the fact that the first.
My lord, that again is wrong with utmost respect, my lord. I have shown, I can, my lord, something which your lordship put, let me show that at least. If I'm wrong, I will sit down, my lord.
To ground number 5.
Yes, my lord, that is what is wrongly, my lord, that's what happens when the High Court doesn't go into the, my lord, what is submitted.
So the next time your client will be more careful.
My lord, I was careful. My lord, may I submit to the honorable chief?
Papers are right that these are only for services, this and that.
My lord, lordships are right. May I just say one thing, my lord? My lord, lordships have put it to me, you did not raise this issue on the basis of the High Court. My lord, I have raised these issues. I should not be, my lord, thrown out for something I have genuinely raised and it is there.
In the invoices, we have seen the accounting entries. If, as you said, the accounting entries were simply for the purposes of the standard rules.
Yes, my lord. That's
could have accepted, but the invoices are not as per any rules. Invoices clearly show transfer of ownership against consideration.
My lord, if your lordship see this invoice, it nowhere shows. That's what happened, my lord. That the authority writes something out of the blue and that, my lord, convinces the, my lord, court that this has happened. My lord, let me at least have the liberty to go back to High Court on my own peril to show, my lord, what the High Court said. Kindly see, my lord, 2 grounds and I won't say further. If this doesn't appeal to your lordship's conscience, my lord, what does the High Court? High Court has not given any independent reason. High Court says you did not raise these issues. My lord, 2 grounds, and if your lordship still feel that I have not raised, I will not say.
Thank you very much. Thank you, Mr.
My lord, at least see that ground, my lord. I have, my lord, the whole impugned order is based on something.
Well, very simple. You can afford to pay tax and you.
That's Lord, I can afford, but the difficulty is I don't want to go against what your lordships have, my lord, held in Tata Motors. My lord, at least keep the question of law open, restricted to this, because it will affect my other subsequent years.
We are not very stressful while dismissing this kind of SLP. You are not going to pay from your pocket. Whatever you will do, you will pass on to the customer.
This is a question of
Question.
Item
21.
Very poorly handled.
But I did, but I then checked up it was there. But I'm a lot grateful.
Please, it's an SLP arising out of the impugned order passed by the Honorable High Court, whereby the trial court order rejecting the plaint was set aside and reversed. Lords, my submission is as per the.
Speak loudly.
Well, as per the averments of the plaint.
Mic and voice both.
As per the averments of the plaint itself, my lords, the suit is prima facie barred by limitation, as there is a fixed time frame. Please.
7-11. You are claiming on the basis of limitation.
Yes, lords.
Limitation can be treated as preliminary issue also. Ultimately, sometime on the point of limitation also,
Please, my lord.
it becomes a mixed question of law and fact.
I totally understand.
Substantially, it may be a question of law, but partly it can still be a question of fact.
Please, my lord.
So, best for you to treat this issue as a preliminary issue, so that you are also, if you are able to prove it is time bound, matter go.
My lords, my only humble submission is, as per Article 54 part, I fall in the category of.
We have to consider Article 54, whether you fall in the first clause or second clause, whether the agreement had a time frame.
It had a time frame.
That is the question, because what you have annexed as the agreement, there is no time frame apart from that 3 months is the time within which the consideration has to be paid. But in the application for Order 7 Rule 11, you have quoted clause 10 where the time frame is given. So let that agreement be exhibited and examined by the court under Order 14 as a preliminary issue.
Please, my lords.
Have to consider the length. While we are not inclined to interpret the report, to the extent we set aside the order rejecting the claim, with the direction to the trial court to decide the suit. From it seems to us that the issue of limitation, based on the objection raised by the petitioners that the suit is hopelessly time barred, ought to be treated as a preliminary issue by the trial court. With direct reporting. We are conscious of the fact that no notice has been issued to the respondents in this regard. However, since the order to the extent of directing the trial court to treat the objection of limitation as preliminary issue
Was otherwise available. Was otherwise available.
Which is from otherwise available to the petitioner, will not cause any prejudice to the respondent. From hence, we do not deem it necessary to hear them at this stage. What will go? We are granting you to cancel the release.
Please, my lords.
You will get it.
May it please, my lord. In this case, the Honorable High Court unfortunately sets the whole process to naught, my lords. I succeed in 2018, then in 2020 and before your lordships.
Serve them, then we'll see.
Your lordships may stay at least the liberty granted, my lords. Otherwise, then they will file before the NCDRC, then I would have to go there, my lords.
Liberty in any case is granted.
They have been given liberty to go to NCDRC.
My lord, she's a widow, my lord. She doesn't have the resources to fight another litigation in NCA.
Delegated to review.
Yes, my lords, before NCDRC of the original order in 2018, which was taken up in SLP before this court, SLP dismissed. Yes, my lords.
The other party came in SLP.
Yes, my lords.
SLP were dismissed.
Yes, my lords.
The other party,
yes,
fight that again goes to High Court.
Yes, my lords.
In that matter, the High Court says to them,
yes,
go and seek review.
Yes,
of
my
the
lords. Yes, my lords. In NCDRC.
This is what the
yes, my lord.
So that's why you are agreeing.
Yes, my lord. And I've not seen the fruits of my decree, my lords, for 8 years, and its execution petition is pending for 8 years now, my lord.
Meanwhile, what is the position? Have they filed any review?
No, as of now, we've not received any notice, my
lord.
Not received any notice, my lord.
as we go to still
Milords, we went for a mediation and the mediation has failed. The only issue that remains is the determination of the permanent alimony. So your lordships may direct them to file their affidavit of asset and liabilities, and then your lordships can determine the amount of permanent alimony. I'm willing to settle.
If mediation has failed,
That mediation, only one date was happened, my lord, before the mediator. Then thereafter, the mediator requested us to come physically. Both the petitioner and respondent could not make it. That's why, my lord, that mediation has failed. For the purpose of that 142.
Palace problem has arisen because of the money consideration.
Yes, my lords.
Money consideration.
The main issue right now that remains before your lordships is the amount of permanent alimony. Otherwise, I am willing to settle all the proceedings. Your lordships may consider directing them to file their affidavit of assets and liabilities.
If you call both the parties next time here, then we have to talk to them.
No.
Yes, Lord.
The parties are to appear in person on the next date of the
Yes, my lord. Because one more thing, there is a child involved, and he is not paying anything. It is we've been separated for almost 6 years now. He's not paying anything for the child. So something for the child.
If you are exploring settlement, then wait for it.
All right.
On one hand, you are wanting settlement, then you are.
Okay.
48.
My lords, in item 48, I am appearing for petitioner wife. The petitioner wife is seeking transfer of section 9 and section 26 of HMA from Patna to Ahmedabad.
Already Ahmedabad, so many cases are pending.
My lord, we are seeking a short accommodation, my lord. The arguing counsel is not available, my lord.
What arguing counsel will do? Already cases between the parties are
My
pending
lords,
in Ahmedabad.
yes, my lords, there are 3 cases already pending which are filed prior to his filing section 9 and 26 in Patna. So one is maintenance, 125 maintenance, one is section 13 divorce petition, and section 7 of guardianship and WhatsApp, which are pending before the Ahmedabad family court, my lords.
My lord, the issue is my father is the power of attorney holder. He is representing me. He is a heart patient, my lords. Traveling to Ahmedabad for him is very difficult.
Why your father should
My lords, the respondent is residing outside, my lords.
In America, my
Respondent is
lord.
residing outside in Rochester, America, and he has filed these 2 section 9 and 26 through the power of attorney, his father in Patna.
Then in any case, matter should go. Then if your husband is not there, then what is the problem?
My lord, the petitioner is also in America with the children, my lords. Both are power of attorney holders.
Maybe
My
then
medical condition is the issue, my lords.
He can appear online.
My lords may give a short accommodation. My lord, the arguing counsel, my lords.
What arguing counsel will do in it?
My lord, he wants.
You want us to impose some cost?
I know, my lords. My apologies, my lords. The matter was listed yesterday, my lords. Today he is indisposed, my lord. That's why a short accommodation, my lords. Any short accommodation.
My lords, even if we see on the merits, the nature of the petition which he has filed belatedly, section 9. My client has, the petitioner has already filed a section 13 petition which is seeking divorce, and he has filed a restitution petition which is a month later. So when these 3 matters are already.
You are also speaking too much. Please wait for a minute.
I'm sorry, my lords.
The father of this husband is some advocate.
No, my lord, is not an advocate.
Why is then filing this kind of petition?
My lords.
Normally, we can understand a fertile legal mind will indulge in all these things.
To that respect, my lords, I don't have instructions.
If you have filed divorce petition, where the question of 9? Allow the transfer.
Deeply
senior, whenever he will come, he will impose some cost if you appear. For you, there is no cost. This is the only incentive we are granting.
My apologies, my lord.
Next 49.
What is the date, my lord?
Ahmedabad.
Sir, great.
ये lady lawyer थी. नहीं है तो जान शुरू हो लगा दो देखते हैं बहुत हो गई.
Your Lordship, this is a petition seeking transfer of divorce proceedings from.
Issued or not?
Notice is issued, Your Lordship.
What is issued? Oh.
My lords, I'm appearing for respondent husband, my lords. My lords, this is a matrimonial dispute. The matter may be referred for the Supreme Court Mediation Center.
Is there any chance of settlement?
No, Your Lordship, and I don't have any instructions regarding settlement in this matter. The wife is only seeking the transfer.
It's a very recent marriage, 23 marriage only. They can either way settle.
Yes,
because sometimes they find that they will not be able to live together. Then this is the right age that they should part ways. And if they can reconcile and can live together, then nothing like that. So better to explore possibility of it. Say on the suggestion of non-counsel to the party, the matter is referred to the Supreme Court Mediation Center. The learned mediator may initially, the parties may initially join before the mediator online, and if need be, they would appear in person as well. Post the matter after 6 or 8 weeks on so.
Highly grateful.
Grateful.